This is Mike Franklin, a property tax guy, and today's July 8th, 2024. And today we're going to talk about the video recording of small claims assessment review hearings, or lack thereof. A couple years back, I submitted the application for audiovisual coverage of the SCAR hearing down in the Broome County in the 6th Judicial District. And so I submitted it to the court, and this is the application. They want to know, which courts. In this case, this is for the 5th Judicial District, so I want to be able to do it in every county for small claims assessment review, for all SCAR hearings and all SCAR hearing officers. And I mean, a video for later broadcast, audio for later broadcast throughout the entire proceeding. My name and my media organization, which is Assessor Audit on YouTube, Judicial Audit on YouTube, and of course the property tax guy, .com for my assessment challenges, but mainly Assessor Audit. So I filled that out, and I got this denial letter. Let me see here. Okay. So I got this email from the administrative judge from the 6th Judicial District. His name is Eugene Faughnan. And I don't know if it was actually written by him, but it says it was. First, he goes on to tell me that, he can't give me legal advice. Well, I didn't ask him for his legal advice. He says, "I'm sorry you were dissatisfied with the prior response you received, but upon further review, I must inform you that it was neither arbitrary nor capricious and was entirely accurate and appropriate." Well, I disagree with that. It was arbitrary and capricious, and it was not accurate nor appropriate. And we'll get into the reasons why a little later. He says, Real Property Tax Law 735 reads in pertinent part that no transcript of testimony shall be made at the small claims assessment review hearing. That's not what Section 735 says, and I'll show you that in a little bit exactly what it says. But he goes on to say, on its face, this provision prohibits the recording of a SCAR hearing. It does nothing of the sort. What it does is it indicates that the decisions are based on determination, not precedent. And because they're based on determination, there's no need for precedent. So there's no need for case law. There's no need for transcripts. But a video recording is not a transcript. Transcript is in trans, as in script, as in scribe, as in writing. Translate to writing. A video is not a translation to writing. He says, in addition, 131.1C of the court rule specifically states that audio-visual coverage of party or witness testimony in any court proceeding other than a plea at an arraignment is prohibited. Well, we all know that that's not true. You see it routinely, and an assessment hearing, an administrative hearing, is not a rape case or a murder case. It's supposed to be the equitable distribution of the tax burden, and there's no need to protect rape victims or children. So that's not relevant. In addition, the media credentials you submitted are insufficient and do not establish that you are a bona fide member of the media. And bona fide definition is it's not deceitful. It's not intended to be deceitful, and it's done sincerely. And to suggest that I'm not sincere or I'm being deceitful, well, it is libelous. And what the administrative judge, which is really astounding that a state Supreme Court judge isn't aware that every person in this country has First Amendment rights, First Amendment rights of press. And CNN or Fox have more press rights than any individual, including myself. And it's just astounding that he would suggest otherwise. If he doesn't know, that's really trouble. If he doesn't know, if he does know, and is denying me my right to record this, it's as highly disingenuous and unbecoming. Accordingly, no further action will be taken. Blah blah blah. He's not going to be allowed the recording. And so what he did was they scheduled the hearing in this courtroom, this enormous courtroom, probably 20-foot high ceilings. There were 3 court police, one of them hovering over me to make certain I didn't record the hearing. It's just a monumental waste of taxpayer money. And there are 3 more hearing or court police out in the hallway, all for an assessment hearing. It's just ridiculous. But anyway, we'll get into those details a little bit later. So again, this is the application, and then I filled out an application, and I'm going to do an addendum for it. Here we go. And I'd like to review this with you. Okay, so this again, this is the addendum for my application to audio record. For audio visual consideration for all small claims assessment review hearings. There is nothing more public than assessment matters. I have heard the following arguments regarding SCAR hearings being recorded. From 6th Judicial District Administrative Judge Eugene Faughnan. Real Property Tax Law 735 reads in pertinent part that no transcript of testimony shall be made of small claims assessment review hearings. On its face, this provision prohibits the recording of SCAR hearings. Let's take a look at Section 735. The Consolidated Laws, Real Property Tax Law 735, determination not precedent. No transcript of testimony shall be made of a small claims assessment review hearing. Again, transcript, trans as in translate, script as in scribe, as in writing, translate to writing. The hearing officer's decision of a petition for small claims assessment review shall, shall not constitute precedent for any purpose or proceeding involving the parties or any other person or persons, except as provided in Section 739 of this title. So again, it's determination, not precedent. It's got nothing to do with video recording. So here was my response. And again, I want to read that again. No transcript of testimony shall be made of small claims assessment review hearings. So there's no transcript. There's no stenographer. There's no need for a stenographer because the cases are decided on determination, not precedent. It's got nothing to do with video recording the hearing. My response. Actually, on its face, this provision does not prohibit the recording of SCAR hearings. On its face, this provision says there are no transcripts. Trans, as in translate, script as in scribe, as in writing. Transcript, translate to writing. The video is not a translation to writing. The 735 provision's intent is that the cases be decided by determination, not precedent. Video recording does not preclude that. Real Property Tax Law 735 has nothing to do with video recordings. Video recordings are not transcripts. The intent of video recording of a SCAR hearing has nothing to do with precedent. Section 131.1, 6th Judicial District Administrative Judge Eugene Faughnan says the following. 131.1 subdivision C of the court rule specifically states that audio-visual coverage of party or witness testimony in any court proceeding other than a plea or an arraignment is prohibited. Suggesting that, and my response is, suggesting that audio-visual recording of public SCAR hearing is prohibited is in violation of the First Amendment, freedom of press, and is arbitrary and capricious self-dealing. audiovisual recording of party and witness testimony is commonplace. It's the court is a service business. They're providing service to the public. The intent of it is not to see how they cannot be accountable to the public or to make their jobs as easy as possible. That simply is not their intent. Is not the intent of their function. The administrative order of the chief administrative judge of the courts. So here's the actual rules of the administrative judge. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, which is what I'm looking for, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the unified court system to facilitate the audio-visual coverage of court proceedings to the fullest extent permitted by New York civil rights law and other statutes, as interpreted by New York courts pursuant to the rules set forth below. And my response is, there has been no citation of any instance that recording a SCAR hearing would violate civil rights law or other statutes. And as far as interpreted by the New York courts pursuant to the rules set forth below, and I'll get into the rest of 131. But still, the First Amendment to the Constitution is the highest law of the land, and if they're going to subvert people's First Amendment right to press, they have to have a reasonable explanation, such as to protect, rape victims or children, things that make sense, not just because they said so, or because it makes it convenient for them. And again, the Constitution annotated Title VI, Clause 2, Supremacy Clause. The Constitution and the laws of the United States, which shall be made in pursuance thereof, and of all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. So, the Constitution, the First Amendment, is the law of the land. And so here's my response is limiting the freedom of press for the convenience of a state court is inconsistent with both 131A, 131.1A, and the First Amendment. SCAR hearings are public, and the public has a right to record public officials in the course of their duties. In order to limit press coverage, there needs to be reasonable justification, such as protecting children or rape victims. There is no legitimate reason to limit the press from recording public matters such as assessment hearings. In SCAR hearings, there is no one to protect if the property owner wishes the hearing to be recorded. The government, hearing officer, nor assessor have any expectation of privacy. And it is of great public interest that there be accountability and transparency in assessment matters. Again, 6th Judicial District Administrative Judge Eugene Faughnan says, the media credentials you've submitted are insufficient and do not establish that you are a bona fide member of the media. And my response is, every person has First Amendment rights of the press. CNN nor Fox have any more First Amendment rights to press as any individual. And frankly, it's really concerning. The state Supreme Court judge is not aware of this. It's just, so either he doesn't know, which is very, very concerning, or if he does know, he's being disingenuous, and it's unbecoming. His disingenuous response is unbecoming an administrative judge. And my response is, every First Amendment right, every person has First Amendment rights to the press. I already gone through them. 131E, nothing in these rules is intended to restrict the power and discretion of the presiding judge to control the conduct of judicial proceedings? My response is, and again, this is a rule, this is one of the sections of the rules of the administrative judge. And my response is that this is certainly the case. A judge/hearing officer has reasonable powers to control decorum, but this does not allow the judge to subvert First Amendment rights. The judge's discretion needs to be reasonable, not simply so because he or she said so. The fact that Board of Assessment Review hearings that are live streamed on YouTube have not been problematic in this regard would indicate it also would not be an issue with SCAR hearings. Again, there's nothing more public than assessment matters, and it is of significant public interest that assessment matters be transparent and accountable. I request authorization to video record all small claims assessment review hearings in the 5th, and in this case, 6th judicial districts to relay for public interest purposes on my YouTube channels, websites, and other social media outlets. So again, I think it's important for the public to know how assessors behave in these small claims assessment review hearings. It's important for the public to see how the whole process works and how the hearing officers behave, and frankly, how I behave and the taxpayer. You know, it's a transparency issue, and if it's recorded, I believe that everyone will behave with more integrity because it's going to be available for the public to see. And so everybody will be more careful about what it is they say, and they'll be more accurate about what they say, and they'll be more reasonable in their dealings. So I think it's critically important that these SCAR hearings be recorded and available online. And you know, assessments are important because home ownership in New York State is essentially an illusion. If you don't pay your property taxes, you could be removed at gunpoint. And so essentially you're renting from the government. So what we're protecting here is the illusion of home ownership, because there really is no such thing as home ownership. But the illusion of home ownership is important because people need a stable environment to raise their children, and they need to feel as though the process is fair. And in many cases, it is not. I've done this in 36 counties, and I've seen all sorts of tomfoolery. I've seen assessors stick it to the out-of-town people they perceive to be rich, you know, who have second homes, and they take it easy on their local cronies. I've seen assessors just, you know, in general, take it easy on their cronies, and you know, some people get favorable treatment and some people do not. I've seen where assessors take kickbacks, and everything in between. And so a good assessor is one who responds to taxpayers promptly, looks into their concerns in good faith, and has an opinion, and politely points people their appeal options if they disagree. That's all there is to it. But so this is about the integrity of the assessment process. It's also about the integrity of the court system. And if the court system is hiding things from the public, you know, it's basically a violation of their own regulations. Like they say, in order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of judicial branch in civil society, it is the policy of the unified court system to facilitate the audio-visual coverage of court proceedings. And then they go on to say, to the fullest extent permitted by New York civil rights law and other statutes as interpreted by the courts. In other words, they want it to be accessible, you know, so long as it's in their best interest, which is basically the definition of self-dealing. So what I'm saying is that if they're going to deny the recording of any hearing, there has to be a logical explanation that is appealable. So, you know, it just can't be the opinion of one person for their own interests. If you disagree, you should be able to appeal to a higher level. But just saying that it's not allowed is completely unacceptable. This is Mike Franklin, the property tax guy.